Hey, welcome to today's video. I'm Richard Chapo. I'm an internet lawyer down in San Diego, California. So today we're taking a look at the CCPA, the California Consumer Privacy Act, and asking the question, can businesses limit consumer rights under the CCPA? So the CCPA is a new privacy law in California. It was enacted in summer of 2018. It goes into effect January 1st, 2020. Now, the act is unique for privacy laws in the United States in that it grants consumers bevy of rights. And so you can do things like ask businesses to produce all the information they have about you, to ask them what they've been doing with the information, to tell them to delete certain parts, to tell them not to sell certain aspects of the information, so on and so forth. And so when laws of these sorts come out, businesses often will try to limit their impact by including language in agreements that limit those rights. So essentially, language will read something like, you waive all your rights under the CCPA to request personal data from us, or something of that sort. And the effectiveness of that stuff, sometimes it's good, sometimes it doesn't work out so well. So probably one of the more famous cases where it didn't work out well is Palmer versus ClearGear. This is a case that's somewhat infamous in the legal community. ClearGear was an e-commerce site, and they were selling different types of goods. The Palmers made a purchase. They were unhappy with their goods, and they left a negative review on a site, maybe ripoffreport.com or perhaps Yelp. I'm not sure. And the interesting thing of that was that ClearGear had included a clause in their terms and conditions that said that if you purchase a good from us, you agree not to leave a negative review on any website. Must be nice. Small free speech violation, but hey, they're obviously trying it. And to make matters worse, if you did leave a negative review, you owed ClearGear $3,500. And so as things rolled along, ClearGear got wind of the fact the Palmers had left a negative review, and so they sent the Palmers an invoice for $3,500. And you can imagine the Palmers' response, which I believe was various curse words and probably the raising of a certain middle finger on one hand. And they didn't pay it. And then ClearGear, somebody needed a lawyer. ClearGear decided to report the Palmers to the credit agencies. Yes, listing the $3,500 as an unpaid overdue debt, thus damaging the credit ratings of the Palmers. Not a smart move. I don't know who at ClearGear thought that this was a wise act, but well, there you go. So you can imagine what happened next. The Palmers started complaining on social media, and the media got wind of it, and a whole mountain of bad publicity rained down upon ClearGear, who I think we can agree probably richly deserved it. And the next thing you knew, law firms were agreeing to, sue ClearGear on behalf of the Palmers for free. And in fact, a lawsuit was filed. And now it turns out that ClearGear was, I believe, based in Europe. It wasn't a U.S. company. And so ClearGear didn't show up for the trial. And it went pretty much the way you would imagine. The judge invalidated the terms and conditions. I believe, issued an order to the credit agencies to remove the $3,500 unpaid debt, and then awarded $300,000 to the Palmers against ClearGear in the form of damages and attorney's fees. So, yeah, pretty much what you would expect. Now, that's obviously an egregious case. I give you some free legal advice. Yeah, you probably don't want to put language like that in your terms and conditions. You're just asking to get punched in the face, metaphorically, of course. But that doesn't mean that businesses can't, in some situations, limit the rights of consumers. So what about under the CCPA? Well, the CCPA actually addressed this. It's kind of shocking because California legislatures tend to leave these kinds of issues out of laws, but nope. In this case, you can see the language right there in front of you, Section 1798.192, which reads, any provision of a contract or agreement of any kind that purports to waive or limit in any way a consumer's right under this title, including, but not limited to, any right to a remedy or means of enforcement, shall be deemed contrary to public policy and shall be void and unenforceable. Whew. It's like reading Hemingway. It just flows. So the language there is pretty clear. And if you have any doubts, terms and conditions or terms of service, terms of use, they're all the same thing. They are a contract. So you cannot put something in your contract to try to circumvent the CCPA. Is this the end of the story? Not really. there's going to be an interesting bit of litigation that arises in a few years, and it's going to be because of a conflict between the CCPA and federal law. Now, California legislature, the politicians there are infamous for passing laws that conflict with other federal laws and state laws. And where they conflict with federal laws typically trump state laws. They're typically going to be the enforceable law, not the state law, under something called the Supremacy Clause. Now, in this situation, what we have is under the CCPA, individuals are allowed to sue for data breaches. They're allowed to bring private right of actions. Now, so let's look at an example. Capital One, right now as I'm recording this, last week Capital One reported they had been hacked and a huge amount of personal information had been swiped. Okay, now if this had happened in 2020, after the CCPA came into effect, individuals who were affected by that, who are California residents, could sue Capital One for violating the CCPA. Now, would individuals actually do that? No. Instead, what they would do is bind together as consumers in a class action lawsuit. It's kind of a gathering of a large number of plaintiffs who all had the same claim against the same company. And they would do that. Now, under federal law, in a case called at&t Mobility versus Concepcion, decided in 2011 by the Supreme Court said that the Federal Arbitration Act could be used to limit class action lawsuits. And in fact, if you go look at the websites or the terms and conditions of most big companies online now, and certainly all of my clients, you're going to see a mandatory arbitration clause included in the terms and conditions. And so we have a conflict between that case and that mandatory arbitration clause and the CCPA provision saying that you cannot limit a consumer's right under a contract. And the reason for that, as part of the mandatory arbitration clause, you're going to include language in there in which the individuals waive their right to file a class action lawsuit. And again, the Supreme Court has stated this is absolutely legitimate. In that case, at&t Mobility versus Concepcion. So we're going to have a conflict, and oodles of money are going to be spent litigating this issue. And the reason for that is because if the Federal Arbitration Act is determined to trump the CCPA, no pun intended, that's going to essentially gut all private right of actions against against businesses under the CCPA. And that means, in English, that it's going to be very, very rare for individuals to actually sue companies under the CCPA. Who cares? Why is that important? Well, because then that means the only remedy that's really going to be left is for the Attorney General of California to bring actions. And the California Attorney General has limited resources and limited manpower. That office is not going to file thousands and thousands of enforcement actions every year. They just don't have the money. They don't have the manpower. And quite honestly, I don't think they have the motivation. They don't seem very excited about this law. But that's another story. Whereas if you allowed private right of actions, well, we all know there are lawyers everywhere. And, they can bring lawsuits right and left and what have you. So it's going to be a fascinating situation to see play out. And now, what do you do if you have a website or an app? Well, you're going to have to talk to your lawyer. Going to have to weigh the positives and the negatives of each approach, and then make a decision, an informed decision based on those potential ramifications, and so you know what you're doing going forward. Some people will include the mandatory arbitration clause, some people will not. But it is certainly a way to potentially at least leverage the CCPA. So make sure you talk to your attorney. If you don't have an attorney, you can always contact me. You can reach me through SoCalInternetLawyer.com. If you have questions or comments regarding this, you can also contact me or leave them in the comment section below. However, please do not post any confidential or sensitive information because, of course, the comment section here on YouTube is available to the public. So if you're interested in the CCPA and learning more, you have other questions, consider subscribing to this channel. We'll be posting a bevy of videos on the CCPA, and hopefully you'll be able to find answers there. Otherwise, thanks for watching. Have yourself a good one.